Good morning. Welcome to the Supreme Court of the United Kingdom. This morning at 11 o'clock, we will be observing 1 minute's silence as an act of remembrance for all those who lost their lives and all others who were affected by the terror attack on London Bridge 1 year ago. I will tell you when the 1 minute silence has ended. It's now 11 o'clock. The 1 minute silence has now ended. Thank you for your mark of respect. Today, we are hearing the appeal in TN Vietnam against the Secretary of State for the Home Department and the Lord Chancellor. Reporting restrictions apply in this case. The court has ordered that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of her family in connection with these proceedings. This appeal concerns the legal consequences of a ruling that the Asylum and Immigration Tribunal Fast Track Procedure Rules 2005 were ultra vires. The Supreme Court is asked to decide, first, are individual appeal decisions taken under the 2005 rules automatically a nullity? Secondly, if not, what is the correct approach to take when considering applications to quash or set aside appeal decisions taken under the 2005 rules? And thirdly, was there procedural unfairness on the facts of TN's case? I'm Lord Lloyd Jones. I'm sitting today with Lord Briggs, Lady Arden, Lord Sales.
Good morning.
And Lord Stevens. The appellant, TN, is represented by Lord Panic, Queen's Counsel, Stephanie Harrison, Queen's Counsel, Anthony Bourne. First respondent, the Secretary of State for the Home Department, is represented by Mr. Robin Tam, Queen's Counsel, and Natasha Barnes. Second respondent, Lord Chancellor, is represented by Julie Anderson. There are two interveners in this case. The Helen Bamber Foundation is represented by Charlotte Kilroy, Queen's Counsel, and Shu Xin Lu. Detention Action, the second intervener, is represented by Charlotte Kilroy, Queen's Counsel, Jason Pobjoy, and George Molyneux. Lord Panic.
Thank you very much, my lord. Good morning, my lords. Good morning, my lady. This appeal concerns the consequences of asylum appeals being heard under a process which the courts have found to be structurally unfair to asylum seekers. And the issue for the court is how that finding is to be applied in the circumstances of individual cases. Is it, as we submit, sufficient for the asylum seeker to rely on the systematic unfairness to overturn the decision in her case? Or does she need to prove more? And if so, what? And if so, has TN done so in the circumstances of this case? My submission for TN is that it does suffice for her purposes that her appeal was heard under a structurally unfair system. I say that in those circumstances, when she makes her application, no valid appeal has taken place. The decision of the tribunal cannot stand. She is entitled to have her appeal heard under a fair system. Ms. Harrison, who appears with me for TN, will then submit a second and third alternative basis for the appeal. The Court of Appeal should at least have recognised that where factors identified by Lord Dyson as establishing the structural unfairness apply in the individual case, that establishes unfairness, or at least a presumption, which it is for the Secretary of State to rebut. And the third alternative, which Ms. Harrison will also address, is that the Court of Appeal erred in failing to find that the structural unfairness did result in specific unfairness on the facts of the present case. The court has, I hope, seen the background to these issues. Mr. Justice Ouseley held at first instance, it's paragraphs 13 through to 41 of his Lordship's judgment, which is at EF 229, that the asylum appeal of TN under the fast track rules 2005 was heard under a structurally unfair system. And Mr. Justice Ouseley therefore held that the fast track rules 2005 were ultra vires because of the structural unfairness. His Lordship held that there was no material difference in these respects between the 2005 rules, under which TN's case was heard, and the 2014 rules, which were the subject of a Court of Appeal decision in 2015, where Lord Dyson gave the judgment, and my Lord Briggs and Lord Justice Bean agreed with Lord Dyson. Can I invite the court to go to Lord Dyson's judgment for the Court of Appeal on the 2014 rules? The court has that in the 4-volume of authorities at EW 2298. And the court sees at EW 2302 that Lord Dyson summarises the relevant rules at paragraph 6 through to paragraph 11. Paragraph 6, a notice of appeal had to be given within 2 working days after the asylum decision, subject to an exception where the interests of justice so required. Paragraph 7 required the Respondents' Secretary of State to provide documents within another 2 days, and Rule 8 required a hearing within 3 working days or as soon as practicable. And Rule 9 required the tribunal to conclude the hearing on the date fixed for the hearing, again subject to an exception, and the exceptions are in Rule 10, an adjournment if the appeal could not justly be decided on that date, and Rule 14 at paragraph 11, an exception in B, if the tribunal is satisfied the case cannot justly be decided within the timescales provided for in the fast track rules, the so-called safeguards, which Lord Dyson then addressed, as I'll show the court. There's a helpful table at paragraph 12 identifying how these fast track rules differed from the standard rules, and I won't read it out, but it's all helpfully set out there. At paragraph 19, which is on EF 2305, Lord Dyson accepted that many of these asylum appeals turn on the credibility of the appellant, and therefore there's a need to produce corroborative evidence. The combination of a highly expedited timetable and the fact the appellant is in detention makes this task very difficult. At paragraph 20, his lordship set out what the legal representative of the appellant needs to do within this abbreviated timescale, checking whether the general detention criteria have been properly applied, making representations where appropriate that the appellant is unlawfully detained, applying for bail and dealing with all that, taking instructions from the appellant on the refusal letter, preparing the appellant's statement, checking it, having it signed, response to the refusal letter, which any expert will need to take into account, translation of documents, arranging for expert evidence, which is, of course, material in many of these cases, and making an application where appropriate for the appeal to be transferred out of the fast track procedure. So Lord Dyson noted all of that. He also noted at paragraph 21 that many of these appellants, well, all of these appellants in the fast track are in detention, so they have limited access to their legal representatives, and there was some evidence relating to that. The judgment, of course, all of it needs to be read, but can I highlight paragraph 37 on page 2309. These appeals are often factually complex, they're difficult, they raise difficult issues of law. Lord Dyson said that his lordship was unpersuaded the safeguards are sufficient to overcome the unfairness inherent in a system which requires asylum seekers to prepare and present their appeals within 7 days of the decisions which they seek to challenge. And at paragraph 39, his lordship dealt with the so-called safeguards in rules 12 and 14, and he said in the penultimate line on that page, at first sight, the argument based on rule 14 seems to be formidable. If an appeal cannot be decided justly within the time limits, it must be transferred out. Why is this not a complete answer to the claimant's challenge? And his lordship answered that question at paragraph 42 and following. At 42, his lordship was satisfied that the rule does not provide the complete answer to the claimant's case that at first sight it seems to offer. At first, it may be difficult for the appellant to persuade the tribunal that the appeal cannot be justly determined in the limited time available. There may not have been sufficient time to complete inquiries into possible further evidence. The focus of the preparation will be on the search for evidence to corroborate the account in rebuttal of the adverse findings. 7 days is bound to be insufficient in a significant number of cases. He's referred to the difficulties facing legal representatives. It may not be possible for them to say whether the further inquiries they wish to make are likely to be fruitful. And at 43, the fact that the opportunity to seek a transfer out only arises at the appeal hearing itself has the consequence that the appellant is required to argue that the evidence that has already been submitted in support of the appeal is insufficient. The appellant is placed in a very difficult position. The stronger the case he seeks to advance for a transfer, on the footing that there are material gaps in his evidence which he needs time to fill by obtaining further evidence, the more he damages his prospects of succeeding in his appeal if the tribunal refuses to transfer the case out of the fast track. In order to explain why the timescales are unjust, the appellant has to identify all the evidential gaps in his case. But if the application to transfer is refused, the appellant will then have to persuade the judge that the appeal should be allowed notwithstanding these gaps. I accept the submission of Ms. Leven. This puts the appellant in an invidious position and is unfair and unjust. And then at 44, I won't read it all out, but at 44, his lordship also explained that the rules create an expectation that these time limits will usually be applied. And at the end of paragraph 44, by the time of the hearing, the Secretary of State and the first tier tribunal will have prepared for the appeal. There will be a momentum in favour of proceeding with the hearing, which it will be difficult for the appellant to stop. And then his conclusions at 45 and 49. At 45, to summarise, in my view, the time limits are so tight as to make it impossible for there to be a fair hearing of appeals in a significant number of cases. The safeguards do not provide a sufficient answer. The system is therefore structurally unfair and unjust. The scheme does not adequately take account of the complexity and difficulty of many asylum appeals, the gravity of the issues, the measure of the task that faces legal representatives taking instructions from their clients who are in detention. Some relaxation of the time limits is necessary. It's not for the court to prescribe what is required. A lawful scheme must properly take into account the factors to which I've referred, whilst I acknowledge giving effect to the entirely proper aim of processing the appeals as quickly as possible, consistent with fairness and justice. And he concludes at 49 over the page, 2312, for these reasons, the fast track rules are systemically unfair and unjust. The object of the Secretary of State is entirely laudable, but many of these appeals succeed. They're placed in the fast track so they can be handled quickly and efficiently. The consequences of an asylum seeker, of mistakes are potentially disastrous. And he refers to section 22.4, recognising that justice and fairness should not be sacrificed on an altar of speed and efficiency. So that's what Lord Dyson decided. As the court sees from the bottom of page 2312, the Lord Chancellor sought to appeal against that judgment, but this court denied permission to appeal. Now, as I've mentioned, the present case was decided not under those rules, the 2014 rules, but under the earlier rules, the 2005 rules. And Mr. Justice Ouseley was satisfied in the present case for reasons which his lordship gave at paragraphs 13 through to 41 of his lordship's judgment. If I could ask the court to turn to EF 229 in the appendix, EF 229, his lordship was satisfied that the same conclusions applied to the earlier 2005 rules under which TN's case was decided. And all of those paragraphs need to be read, but can I just highlight paragraph 18, which is on EF 230, where his lordship said neither party pointed to any material difference between the structure and content of the 2005 and 2014 rules. There is none, or at least none helpful to the Secretary of State. the crucial timescales, the adjournment powers, the powers to transfer out which contain the safeguards are not materially different. The 2014 rules gave appellants one more day in which to submit appeals, and under the 2005 rules, cases could only be transferred out in exceptional circumstances, but his lordship explained why that was not a material difference. And in the present case, there was no cross appeal by the Secretary of State or the Lord Chancellor to the Court of Appeal against those findings that the Court of Appeal judgment in 2015, the reasoning applied equally to the 2005 rules. Those issues are not in dispute on this appeal. We are concerned today, tomorrow, with the consequences of those conclusions for the individual case. Now, my submission for the appellant is, with great respect, the Court of Appeal in this case, present case, and Mr. Justice Ouseley erred in law. And they did so because they concluded that it was necessary for the appellant to show that the systemic unfairness led to a specific unfairness in the particular circumstances of her case. That is, a particular unfairness more than having had her appeal heard under rules which were systemically unfair. And one sees the reasoning of the Court of Appeal summarised in Lord Justice Singh's judgment at page 209, EF 209, at paragraph 87. At the end of paragraph 87, Lord Justice Singh for the Court of Appeal says in the final sentence, it seems to me, says his lordship, that the answer which my friend Mr. Tam gives to that contention is correct. There has to be shown to be procedural unfairness on the facts of the individual case. And his lordship returns to the point at the end of paragraph 88. His lordship says that requires an assessment of whether there has in fact been procedural unfairness in the individual case. And at paragraph 90, again, his lordship concludes that on the first issue, the appellant's submissions should be rejected. It follows that it is necessary, if an application is made to set aside an earlier appeal decision, to assess whether there was procedural unfairness on the particular facts of that case. There may or may not have been. That will depend on a careful assessment of the individual facts. It is not enough to say that the rules were ultra vires. And similarly, at first instance, Mr. Justice Ouseley, although I draw attention to this because his lordship made an interesting observation at EF 255 and picking it up 5 lines, I'm sorry, at D, picking it up just above D on page EF 255, his lordship said, this is Mr. Justice Ouseley, the Secretary of State might be able to show that there was no unfairness in reality. This is not the same at all as requiring the appellant to show that the result would have been different under a different regime. That is not required. So the unfairness, in his lordship's view, the unfairness that we need to show is more than that the rules were ultra vires, but not so much as to show that there would have been a different result on the facts. Now, our case, as I indicate, is that the appellant has been denied her right, her statutory right, to an appeal under a fair system. She's been denied the opportunity to conduct her appeal under a fair system. I accept, I should make it very clear at the outset, as we do in our written case, that she must make an application. It's no good her simply asserting that her appeal was conducted under an ultra vires system and therefore the appeal decision is null and void. She must apply to the court. And the reason for that is the well-established principle, Lord Radcliffe for the appellate committee in Smith and East Ello. Perhaps I could just turn it up. It's Authorities, Volume 8. And it's at EF 4875. EF 4875. This is Lord Radcliffe speaking for the appellate committee, a well-known statement of principle at the end of 4875, 5 lines up from the bottom. His lordship says an order, even if not made in good faith, is still an act capable of legal consequences. It bears no brand of invalidity upon its forehead unless the necessary proceedings are taken at law to establish the cause of invalidity and to get it quashed or otherwise upset. It will remain as effective for its ostensible purpose as the most impeccable of orders. So we must apply, we must make an application. Yes, my Lord, Lloyd Jones.
Lord Panic, so far as the application is concerned, this matter is before us as a matter of judicial review. But what do you say is the appropriate form of the application?
Well, the appropriate form of application is a judicial review because the same judges who sat in the Court of Appeal in this case also sat as a divisional court, and they held that it is incumbent upon an applicant not to make an application. This matter cannot be resolved by making an application to the first tier tribunal or indeed to the upper tribunal. A judicial review application is required in the circumstances of this type of case, and there's been no appeal from that decision of the same judges sitting as a divisional court. I can give your lordships the reference. It's in volume 7, tab 67, behind, was EF page 4475. Your lordship may have seen Mr. Justice Ouseley said that the appropriate procedure was to apply to the first tier tribunal or the upper tribunal. That went by way of challenge to the divisional court, and the same judges constituted as a divisional court said that was wrong. There needs to be a judicial review application, EF 4475, and neither party has challenged that.
Thank you very much. That was exactly what I had at the back of my mind.
Could I just ask a corollary? I'm so sorry. Could I ask a corollary of that question? We're obviously hearing your argument on automaticity, and you've only just begun, and I'm certainly not expressing any view. But if Mr. Tam were right, and there was therefore no automaticity, would you not then be able to appeal up through the tribunal system if you considered that one of the factors constituting structural unfairness had rendered the decision in your case unfair, so that we would then be looking to see further appeals within the system rather than using judicial review? Maybe you need to, we need to think about it a bit, but what would the position then be?
No, the position would be that we would have an appeal decision which we could only challenge by way of judicial review. We would have to say, we could say, and Ms. Harrison will develop the argument that there is specific unfairness on the facts of this particular case. That could be raised by way of a judicial review, certainly, my lady. But my submission...
I'm so sorry. I'm so sorry. I didn't mean to interrupt you, Lord Panic. I just wanted to know, really, is that exclusively the way of dealing with these matters? If, contrary to your submissions, which we've not yet heard, on which I'm not expressing any view, there could be only an appeal in a specific case of the kind Lord Justice Singh and the Court of Appeal had in mind.
No, we can raise specific unfairness, but we would have to raise it by way of a judicial review application. We cannot go back to the first tier tribunal and say to them there was specific unfairness. That's the whole point of the judgment to which I was just now directing the attention of the court, that the Court of Appeal judges also sat as a divisional court. That's what they held. But we could raise specific unfairness, yes, by way of a judicial review. We also have, in this case, further appeals through the tribunal system, but only if there's a later decision which can be the subject of an appeal. But that's a different matter.
Yes,
in relation to...
Sorry.
No,
in relation to, I was going to say, the divisional court were dealing with a different problem, namely, how do you establish structural unfairness? But if one were beyond that point, and we're not dealing with that point, and I'm not expressing any view, would one then be able to say, well, the tribunals must conduct their proceedings fairly? If nothing else, the Article 6 obligation, and therefore it can all come within the appeal system.
Well, I don't understand that to be the case because of the divisional court judgment that the appeal body, the first tier tribunal, is functus officio. It's made its decision at the end of those appeal proceedings. And if you wish to overturn the judgment of the first tier tribunal on any basis, you have to go by way of judicial review. You can't go back to the appeal tribunal, whether your complaint is structural unfairness or it's specific unfairness on the facts of the individual case. That's what the divisional court say. As I indicated, it's not an issue on this appeal. I'm not saying that we have no opportunity to go to a court on specific unfairness. On the contrary, we can raise specific unfairness by way of judicial review. My legal argument for the appellant is we don't need to. We should win without that, as your ladyship.
I understand that. I do understand that. I'm not expressing a view.
I'm grateful.
Thank you, Lord Fanning.
I'm grateful. Can I turn to, first of all, the statutory provisions under which the fast track rules were made, because we rely upon them. Now, the appellant's appeal was under Section 82 of the 2002 Act, and the court has the relevant provisions in Volume 2 of the authorities behind tab 2, I'm sorry, the core authorities, tab 2, page 2206. Section 82 is the right of appeal, and I won't take time on that because it's not in dispute. The relevant rules were made under Section 106, which is on EF 2208. EF 2208. And that gave the Lord Chancellor a power to make rules regulating the exercise of the right of appeal or prescribing the procedure. And Section 1A, which was introduced, as we see on page 2210, by the 2004 Act, the Asylum and Immigration Treatment of Claimants Act, 1A says, in making rules, the Lord Chancellor shall aim to ensure, A, that the rules are designed to ensure proceedings before the tribunal are handled as fairly, quickly and efficiently as possible, and B, that the rules, where appropriate, confer on members of the tribunal responsibility for ensuring that proceedings before the tribunal are handled as fairly, quickly and efficiently as possible. So that's the 2005 rules. The 2014 rules were made under a different provision. They were made under Section 22 of the Tribunals, Courts and Enforcement Act, which appears behind, well, at page EF 2661, it's tab 17 of the authorities, 2661, section 22, and subsection 2, tribunal procedure rules are to be made by the procedure committee, and subsection 4, power to make the rules is to be exercised with a view to securing A, that in proceedings before the tribunals justice is done, and B, and we emphasise this, that the tribunal system is accessible and fair. The system is accessible and fair. C, the proceedings are handled quickly and efficiently. D, the rules are simple and simply expressed. And E, that the members of the tribunals have a responsibility for ensuring proceedings before the tribunal are handled quickly and efficiently. So there is a distinction between the empowering provisions for the 2005 rules and the 2014 rules, but the section 22 provisions do apply to the 2005 rules with which we are here concerned, and that is for the reason explained by Mr. Justice Ousley in his judgment, which can be found at page 230 in the appendix 230, paragraph 17, on that page at letter D, my lords, my lady, letter D, he explains that when the short life of the Asylum and Immigration Tribunal ended, its functions were transferred to the first tier tribunal in 2010. The transfer of functions order provided for the 2005 rules to have effect as if they were tribunal procedure rules. There is therefore no distinction in terms of varies between the provisions empowering the 2005 and the 2014 rules. So we rely upon the fact that Parliament has required not merely that there shall be fair hearings, Parliament expressly required that the rules ensure that the tribunal system is both accessible and fair. And of course here it was not. Now the respondents' answer, and it's set out in their case, is that systemic unfairness here established does not mean that there has necessarily been unfairness in a specific case. In our submission, that answer begs the vital question of what does it mean to say that a case has not, an appeal has not been determined fairly. The statutory requirement, as I've said, is for a fair system, and our case is that there was not fairness in TN's case because she was denied the opportunity to have her appeal heard under a fair system. We say that it is not surprising that Parliament required not merely fairness on the particular facts, but a fair system. And the reason why it is not surprising, we say, is because procedural fairness requires more than a system whose defects cannot be shown to have prejudiced the appeal of the individual litigant, for example, by affecting the result. Procedural fairness serves additional values to that. And we have drawn attention to what is now the very familiar reasoning of the President for this court in the Osborne case. Can I take the court to Osborne? Although I know it's very familiar to the court, it's at tab 9 of the authorities, EF 2425. And the relevant paragraphs where Lord Reid, the President, addresses these matters can be found starting on EF 2459. Of course, these paragraphs were assessed in the recent Parthon case to which I'm coming, a court which included my Lord Briggs and my Lady L. So at 2459, Lord Reid, the President, addresses at 66, paragraph 66, the purpose of procedural fairness. And he deals there with making better decisions. And at 67, his lordship says there's no doubt one of the virtues of procedurally fair decision making is that it's liable to result in better decisions by ensuring the decision maker receives all relevant information and that it's properly tested. Lord Hoffman observed, however, in AF number 3, the purpose of a fair hearing is not merely to improve the chances of the tribunal reaching the right decision. At least two other important values are also engaged. And the first of those, at paragraph 68, is avoiding the sense of injustice which the person who is the subject of the decision would otherwise feel. Lord Reid says that his lordship would prefer to consider first the reason for that sense of injustice, namely that justice is intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions taken in the exercise of administrative or judicial functions. And his lordship then in the rest of 68 and in 69 draws attention to the leading case of Adam in the Garden of Eden, where, of course, Adam's answers could make no substantive difference to the result or indeed anything else, because God is omniscient. And we say, just looking at what Lord Reid describes as this second purpose of procedural fairness, that for the appellant's asylum appeal to be conducted under a system which is, to quote Lord Dyson, systemically unfair and unjust, and so ultra vires, inevitably, in our submission, promotes precisely that, quote, sense of injustice, unquote, that Lord Reid was concerned about. And similarly, the value of the rule of law, which Lord Reid turns to at the next page, 2460, paragraph 71. The second value is the rule of law. Procedural requirements that decision makers should listen to persons who have something relevant to say promote congruence between the actions of decision makers and the law which should govern their decision, govern their actions. And we say equally in this case that it does breach the rule of law for the appellant to be told your appeal was heard under a system which was systemically unfair and unjust, but you're not entitled, notwithstanding that fact, you're not entitled now to an appeal under a fair and just system. Now, this sense of injustice and, in my submission, undermining of the rule of law that would follow if my friend's submissions are correct are especially troubling in the present context when one bears in mind that when one bears in mind the core of Lord Dyson's reasoning in finding these rules to be systemically unjust and unfair. And that is the shortage of time which the appellant had to conduct all of the tasks needed prior to the hearing, and the point made by Lord Dyson at paragraph 43, which I read out, as to the dilemma imposed on the appellant, who must choose whether to seek an adjournment and thereby advertise the gaps, if any, in her case. And I say also this sense of injustice, this denial of the rule of law, is exacerbated by the fact, and it is a fact, that the other party to the appeal, that is the Secretary of State, is the very person who has decided to place an appellant, including this appellant, into this fast-track system. And that is so because the rules, the 2005 fast-track rules, apply to anyone who the Secretary of State decided to detain in a specified detention centre. The rules themselves are at Authorities tab 1, page 2167. I've not taken the court through these rules because Lord Dyson summarised them so clearly, but what I do need to mention is Rule 5, which is on page 2172, my lady, 2172. This part applies to an appeal to the tribunal, that's the fast track part, where the person giving notice of appeal, A, was in detention under the Immigration Act at a place specified in Schedule 2 when he was served with notice of the decision against which he is appealing. And Schedule 2 appears at 2204, and it's a list of immigration centres. So if you're placed by the Secretary of State in one of those centres, the fast track rules applied to you, and we see this in the first tier tribunal's decision in the present case at page 284 of the appendix. Page 284, my lords, my lady, in paragraph 53, this is the decision of the first tier tribunal judge. Paragraph 53 on 284, he says, I'm satisfied the appeal falls to be considered under the 2005 rules in that the appellant is in detention at Yarlswood Detention Centre and she was so detained when notice was served on her, and she's been in detention continuously. So the tribunal makes no determination as to whether it's appropriate for the fast track rules to be applied, subject, I accept, to the safeguards which Lord Dyson found to be inadequate. Now, we rely on two supporting lines of authority in support, as we put it, in support of our contention that fairness requires a fair system in this type of case. And the first, and there are two lines of authority. One is the line of authority concerning bias cases, and I'll come to that. The other is the approach taken to the court to procedural fairness generally, and the principle that the courts will not, save in exceptional circumstances, deny a remedy because it is suggested that the defects in the structure made no difference on the facts of the individual's case. And this principle was recently looked at, as I mentioned a few moments ago, by this court in the Parthon case, which is at tab number 10, page 2471. This is a judgment given last month, 23rd of October. It is now in the weekly law reports, but we have it in the hand-down version. As certainly my lady, Lady Arden and Lord Briggs will recall, this was a case where the court held that there was a breach of procedural fairness, my Lord Briggs dissenting, when the Secretary of State was considering an application by an employee for a further leave to remain in reliance on a certificate of sponsorship from an employer. And the Secretary of State revoked the sponsor's license without telling the employee applicant who was seeking an extension of his leave to remain, and he had no opportunity to take alternative steps. The court held that that was a breach of procedural fairness, but the court also held, my lady and Lord Wilson dissenting, that procedural fairness did not require the Secretary of State to give any specific period of time to the employee to take such action, because that was a matter of substantive fairness, which it is not for the court to assess. So it's a complicated case, which no doubt explains the length of time that the court considered that particular case. Now, can I take the court to the joint judgment of Lady Black and Lord Kerr? They recognised at paragraph 120, which is on page 2510, by referring to the separate judgment of my Lord Briggs, they noted that there are cases where certainly a remedy will be refused because there would have been no difference to the results. But in the last 5 lines, they point out...
Which paragraph are you?
120, my Lord.
Thank you.
120 on page 2510. They refer to the observations of my Lord Briggs that no one could complain of not having been given an opportunity to make representations if it would have achieved nothing. And there's also a reference to Bank Mellet. And in parentheses, they say at the end of paragraph 120, it is noteworthy, however, in that passage, Lord Newburger was at pains to point out that any argument advanced in support of pointlessness should be very closely examined, as a court will be slow to hold that there's no obligation to give the opportunity when such an obligation is not dispensed with in the relevant statute. Here, of course, the relevant statute requires an appeal under a fair system. They went on, Lady Black and Lord Kerr, to identify that pointlessness can have 2 dimensions. The first is no possibility of bringing about a change of mind. And then they say in the last 4 lines, the second dimension is different. It involves an examination of whether, on becoming aware of the decision, there was simply nothing that the affected person could do to achieve his aims. In other words, there was no other avenue which he or she could explore to avoid the impact of the adverse decision. At 123 over the page 2511, through to 125, they pick up on what was said about the purposes of procedural fairness in Osborne. And there's a valuable statement at 125, quoting from Professor Mark Elliott and Professor Varuhas's book, where they refer to Lord Reed's judgment, in particular the dictum referring to God being given a hearing, and at Adam being given a hearing by God, and at 2512, in the paragraph just before paragraph 126, they say, Eliot and Varohas, on this view, the notion of procedural fairness, which would make no difference, becomes a contradiction in terms, since it rests on an exclusively outcomes-oriented view, which overlooks the much wider role played by procedural fairness in an administrative state that seeks to build constructive relationships between individuals and public bodies by casting the former as participants in the process of governance. We say a similar conclusion should apply to judicial bodies who are making decisions, that the individual must be given a proper opportunity to play her role in the appeal process by participating in a process that is structurally fair. If we go on in the judgment to 134, Lord Kerr and Lady Black there emphasise that the fairness of withholding information is not to be judged on an ex post facto basis. At the time when it was first possible to inform Mr. Parthon of the cancellation of the employer's licence, there was no means of knowing whether he could have been able to obtain a new acceptable sponsor. But this is the time that the fairness of withholding the information falls to be judged. If it was not fair then, it cannot be converted to a condition of fairness because of his subsequent failure to put forward an employer who could have provided a certificate acceptable to the Home Office. And we say the same is true here, that fairness must be judged at the instigation of the appeal when it comes before the first tier tribunal, not by reference to what happened at the hearing. At paragraph 201, Lord Wilson, his judgment at page 2536, at the top of the page, we see the partly dissenting judgment of Lord Wilson, partly dissenting because he, together with my lady, would have found that the applicant was entitled to a specific period of time to address these matters. Lord Wilson, with whom my lady agreed, said at paragraph 201 that they agree with that part of the judgment of Lord Kerr and Lady Black in which they explain why the Secretary of State owed to Mr. Parthon a duty of prompt notification of revocation of the licence, and the Secretary of State, was clearly in breach of it. And my lady's judgment, separate judgment at paragraphs 48 to 51, which is at pages 2490 and 2491, also emphasised the purposes of procedural fairness as set out in Osborne. My lady addressed those matters, and at 52, my lady said procedural fairness is thus an important matter. It makes the law more just and at the same time improves the standards with which decision makers are expected to comply in the 21st century. The judgment of my Lord Briggs, at paragraph 162. Right. Yes, the judgment of my Lord begins at page 2517. My Lord dissented, but my Lord expressed broad agreement at 144 with Lord Kerr and Lady Black's analysis. My Lord dissented at paragraphs 162 to 164 because, as my Lord said at the top of page 2523, my Lord regarded this as a rare example of pointlessness, and that was because on the exceptional facts of this case, Parthon, Mr. Parthon was not complaining of a breach of a fair procedure in considering his application for an extension of his leave to remain. Rather, he wanted notification so he could take other steps to regularize his position. That was my Lord's position in that case. So we rely on Parthon. We rely on it for 3 points of principle. First, we say it supports the argument that the appellant does not need to show that the structural unfairness in the procedure made any substantive difference to the appellant's case. It's enough to show there was not a proper process for the reasons articulated by the President in Osborne and developed in Parthon. In any event, secondly, the case confirms that it would require an exceptional case for the court to be satisfied that a lack of structural fairness defeats the appellant in the individual case, especially when the statutory provisions themselves require a fair system. And thirdly, and in any event, as stated at paragraph 134 by Lady Black and Lord Kerr, agreed to by the other members of the court, procedural fairness must be assessed as at the date, the time of the event in question, here the commencement of the appeal, not by reference to what's occurred or did not occur at the appeal. So we rely on all of that. We also rely on the bias cases, to which I'm coming. I notice, my Lord, it's now midday. That may be a convenient point, although I'm very happy to carry on if the court would prefer me to.
No, we'll take 5 minutes. Thank you very much, Lord Panic.
Thank you very much, my Lord.
Lord Panic.
Thank you very much, my Lord. The other strand of authority I wanted to mention is the case law relating to bias. What happens when the judge is not impartial either subjectively or objectively? And the approach taken by the court to such cases is that the decision which he or she has taken cannot stand, irrespective of whether there can be shown to have been any specific unfairness to the applicant, or indeed whether the same result would have occurred before any other judge. The injustice, the unfairness for which the law provides a remedy is the structural unfairness of the case being heard by a judge who lacks impartiality. And the authority that we rely upon, is Miller and Dixon, which is at page 3770, tab 42. It's a Privy Council case, and the context, 3770, the context was that criminal trials had been heard by temporary sheriffs who lacked security of tenure, and therefore the courts had held there was a lack of objective impartiality. Convicted defendants appealed against their convictions on that ground. Lord Hope, speaking for the board, described at page 3794, one of the arguments advanced by the Solicitor General for the Crown, we see that at 3794, paragraph 61, the Solicitor General said, that identifies who we're talking about, and at 62, Lord Hope says the essential point on which he, the Solicitor General, based his main argument was that the question as to whether the Lord Advocate's Act, that's the act of appointing these temporary sheriffs, was unlawful, had to be tested at the date when the challenge was made. This had to be done in the light of all the facts and circumstances known to exist at that time. All there was a perception that the temporary sheriffs lacked independence. But the reality was that they did not lack independence. In fact, their judgment was unaffected. There were no grounds for saying that the verdicts of guilty were unsafe or the sentences imposed were excessive. The appellants were unable to show that they would derive any real benefit from being retried or sentenced again. He invited us to hold that the decisive factor in these cases was not that the right to an independent and impartial judge had been waived because no plea in bar of trial had been taken at the outset, but that the use of temporary sheriffs in these cases made no difference in fact to the result. 63. In my opinion, says Lord Hope, this argument overlooks the fundamental importance of the convention right to an independent and impartial tribunal, of course a common law right as well. These two concepts are closely linked, and the appearance of independence and impartiality is just as important as the question whether these qualities exist in fact. Justice must not only be done, it must be seen to be done. The function of the convention right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires this matter to be viewed objectively. And then he cites some authority. As Lord Clark said in Rimmer, the question of impartiality has to be judged from the very moment when the judge or tribunal becomes first seized of the case. The question which, at least in a case of perceived impartiality, stands apart from any questions that may be raised about the character, quality, or the effect of any decisions which he takes or acts which he performs in the proceedings. And Lord Hope goes on at 64 to say that there's ample authority in our domestic law to support these propositions. He cites a decision of Lord Justice Clark Ross, who noted that there was no reason to think the complainants did not in fact receive fair trials, and Lord Dunpark said the question was not whether they received fair trials, but whether what the sheriff said was enough to create a suspicion that he might not be impartial. And just above letter E, it's also worth noting that the same rule was applied in the Pinochet case, whereas Lord Brown Wilkinson made clear the result was in no way dependent on the judge personally holding any view or having any way dependent or having any objective regarding the question whether Senator Pinochet should be extradited. The fairness of the proceedings was not in question, but that was not the issue which the House had to decide. The principle of the common law on which these cases depend is the need to preserve public confidence in the administration of justice. And that, we say, chimes very much with the Osborne judgment. That then is what Lord Hope said. Lord Bingham, also speaking for the board, spoke to...
There's a question for you, I think.
Yes, thank you.
There's a question.
Lord Senate, thank you very much indeed. That case relates to the Article 6 right to have an independent and impartial tribunal. But there are other Article 6 cases which indicate that even if there is a breach of Article 6, that the court goes on to examine whether notwithstanding the breach, the proceedings as a whole were fair. And in that respect, I was thinking of Saldus against Turkey, Ibrahim against the United Kingdom, and Views against Belgium. So there are different responses by the European Court of Human Rights in different areas. And I was wondering what your views about that were.
Well, I accept what your lordship says. I'm not putting my case forward on the basis that we are the victims of a breach of Article 6. I am relying on common law rights to an independent and impartial tribunal. And in my submission, the Miller case stands as a proposition of the common law, irrespective of the position that may be adopted, and I don't dispute what your lordship says, in Strasbourg. And the observations of the Privy Council, which I'm reading out to the court, are propositions of the common law, which I say provide a very strong supporting basis for the argument that I am advancing. The approach.
If I could, sorry for interrupting, if I could intervene there, we also have lines of authority, for instance, Joji and Kada, which also, some of them draw a bright line, others draw a test as to whether or not there was specific unfairness in an individual case. So it is not just confined to one line of authority. I was just wondering what your views were about those cases.
Well, I'm not suggesting that the common law is a seamless web. I mean, plainly, there are differences of approach in different contexts. But I do say that this is the orthodox standard position approved by the Privy Council very recently in the Al-Mazidi authority, which I'll come to. And I say this is orthodox law. It is not incumbent on the person who alleges that the judge is other than independent and impartial to need to show anything more than that in order to obtain a remedy, to obtain a new trial. In the criminal context, I accept this is a criminal case, but the same, I say, must be true in the civil context. That's the proposition for which I contend. I say it is orthodox law, and it is well established, and it is well reasoned in my respectful submission, and the court should follow it. And if it's correct, then it strongly supports my contention that just as the structural defect that the judge was objectively or subjectively biased means that his or her judgment cannot stand, equally, if the appeal is heard under a system which is systemically unfair, the appeal decision cannot stand.
Lord Panic.
There's a question from my Lord.
Yes,
Lord
my
Briggs.
Lord. Yes, my Lord.
Before we leave the Miller case, Lord Hope is there distinguishing, it seems to me, between the right to a fair and impartial tribunal on one side, which is fundamental, and questions about whether there has been or hasn't been a fair trial on the other hand, both in paragraph 64 and, well, I think it's all in paragraph 64, actually.
Yes.
As I understand it, you seek to categorize what we are here concerned with as coming on the fundamental side of the line, rather than that, as this person had a fair trial side of the line, because you call it structural. And I think you therefore seek to categorize the lack of an independent or impartial tribunal as structural. And I wonder if you could just help me on what is this notion of structurality, which takes one across the dividing line between the two, in a case where the systemic, or whatever you want to call it, structural issue here is all about fairness rather than independence or impartiality.
Well, a number of answers to that. Of course, independence and impartiality are branches, special branches, but branches of fairness. I mean, they're not based on some other principle. As to the nature of a structural impediment, it was, of course, the Court of Appeal in Lord Dyson's judgment which categorised the defect in the rules as a systemic and or structural defect. It's the Court of Appeal's language, not mine. What I submit it means is that there is some impediment, some defect in the structure, in the rules that are applied to appeals, which are so grave that the whole that the system which is being applied is so defective that it cannot stand. That's why the Court of Appeal approved the order of Mr. Justice Nicol to quash the rules. They were ultra vires and they were quashed. So it is a defect of a nature which goes to the very essence of the rules, the system under which the individual appeals are being heard. That's its nature. And I say that just as one can identify the lack of impartiality of the judge as a structural defect, which is far more serious than regrettable unfairness in a particular case, equally here too, one is concerned with some overarching unfairness that has the consequence for which we contend. That's the way I'm putting the case. It's more than unfairness in a particular case, and it ties in with Osborne, with the whole purposes of procedural fairness being not simply a concern about what happens or doesn't happen on the facts of a particular case. Procedural fairness has more important, even more important values that it seeks to protect. That's how I'm putting the case. I entirely accept that there are different lines of authority relating to the consequences of a lack of impartiality. I say this is the governing authority, not, as far as I'm aware, ever been disproved or overruled in any later case. Of course, it's a Privy Council case, it's a board case, it's not technically binding, but the authority of those who were party to the advice in Miller gives it a particular force in my submission. Lord Bingham made observations to like...
Panic, I think my Lady Arden has a question.
I was just going to reinforce your last submission by pointing out that in Serafin and Markovitz this year, the Supreme Court held that a decision of a judge was not have no effect where impartiality was shown.
Well, I'm very grateful to my lady. Thank you.
Just reinforcing your point. That's all.
I can't remember whether Miller and Dixon was cited or was relied upon there. But I'm grateful to my lady. I say this is a proposition, a common law proposition for which there is not only high authority, but it is a proposition that speaks for itself once one recognises the importance of the values that are being that underline the assessment in a case of this sort. I ought just to show this court what Lord Bingham said, because he spoke to like effect at 3778, paragraph 15. Lord Bingham refers to the Solicitor General seeking to rebut the argument by distinguishing the Stars case essentially on the ground that the challenge in that case, that was the case that established a lack of objective impartiality, essentially on the ground the challenge in that case had been raised at a relatively early stage of the proceedings before the trial had been concluded. And over the page, at page 3778, 9 at letter C, his lordship says it could be seen that the trials of the accused had been fair in all respects. Miller had been convicted by a jury. No criticism was made of the summing up by the temporary sheriff. Hayne had pleaded guilty. It made no practical difference that her plea was tendered to a temporary sheriff, and there was nothing to suggest her sentence was excessive. Stewart no longer complained of his conviction before the 20th of May 1999, and the non-custodial sentences after that date were moderate. Tracy had been convicted on a summary complaint, demonstrated no grounds to impugn conviction or sentence. Whatever the theoretical defects to which the appointments of the respective temporary sheriffs were subject, none of them was said to have shown any lack of independence or impartiality. None of the accused could show that he or she had in the event suffered any injustice. With these last submissions of the Solicitor General, I, says Lord Bingham, have much sympathy. There is indeed nothing to suggest that the outcomes of any of these cases would have been different had the relevant stages of the prosecution been conducted before permanent instead of temporary judges. There is no reason to doubt that the conduct of all the temporary sheriffs involved was impeccable. No reason to suppose that any of the accused suffered any substantial injustice. But I cannot accept that the outcome in Stars would have been different had the challenge been raised after the trial in that case was concluded, and it is, in my view, clear from authority that the right of the accused in criminal proceedings to be tried by an independent impartial tribunal is one which, unless validly waived, cannot be compromised or eroded. And his lordship then refers to locker bail. He does refer, Lord Bingham, to the European Court at paragraph 19, that as further support rather than the primary basis of his lordship's judgment. I should also refer to the third detailed speech in the case, detailed advice in the case, which was from Lord Clyde at paragraphs 82 and 83, and it's the like effect. I won't read it all out given the time is passing, but that also I draw to the attention of this case. So we say that the bias cases are relevant. The litigant can complain of the biased judge, subjectively or objectively, whether or not she can show that there was any injustice, any unfairness in the circumstances of her case, other than the structural unfairness, as I've sought to describe it, that arises. It suffices her case was heard and decided under a system in which there was this procedural defect of a major importance. And we therefore rely upon that line of authorities. We say the law entitles my client to a system which meets the standards necessary to promote public confidence in the appellate system. She was entitled to the opportunity to have her case heard before a tribunal under rules which were not systemically unfair. Therefore, we submit the structural unfairness in her case is unfairness enough. We add to that that these issues arise in the context of asylum appeals, where it has long been established by the court that because of the gravity of the issues that are raised in asylum appeals, only the highest standards of fairness will suffice. One authority for that proposition, it's Lord Justice Bingham, as he then was, at page 26 2642. This is the Court of Appeal in 1989, the Thirakumar case, page 2642. Lord Justice Bingham, speaking for the court, because Lord Justice Mann expressly agreed, at page 2654, in the middle of the page, under the heading Fairness, the third line down under Fairness at page 2654, this is Lord Justice Bingham. His Lordship says, "It is, however, plain that asylum decisions are of such moment that only the highest standards of fairness will suffice." That's the principle applied many times since. Can I next mention the concern that was expressed by Lord Justice Singh in the Court of Appeal? It's paragraph 80 of his Lordship's judgment. If the court wishes to, please turn it up at page 208. The concern expressed by Lord Justice Singh at page 208 that there's a need, as his Lordship put it, for great caution in a context like the present, because, as his Lordship points out, there may be all sorts of subsequent decisions which arise and which are contingent upon the validity or invalidity of the appeal decision. My answer to that concern is that we are concerned in these proceedings, and only concerned with the question of whether the appellant has received a valid hearing of her appeal such that she is entitled to a further hearing of her appeal. The appeal with which we are concerned was, in my submission, the direct product of the structural unfairness of which she complains and which was found by Lord Dyson's Court of Appeal. If there are any consequential decisions arising, the validity of which need to be considered, they can be addressed if and when they arise. This court has considered such matters in the DN Rwanda case, which is at tab 6 of the authorities, page 2313. And Lord Kerr, speaking for the court, explained at paragraph 17 through to 20, it's page 2326, my lords, my lady, page 2326. Lord Kerr explained that the Secretary of State had acted unlawfully in deciding to deport the claimant in that case, and therefore the consequent decision to detain the claimant for the purpose of deportation was also unlawful. The detention could not be divorced from the deportation. And it was no answer to that, said Lord Kerr for the court, that there was an independent judicial decision upholding the decision to deport. And he also said, it's paragraph 20 on page 2327, that the need for finality in litigation does not warrant displacement of these principles. As Lord Carnworth says, finality and legal certainty are desirable objectives, but they cannot extinguish a clear legal right. And in this case, DN was detained on the foot of an intended and then actual deportation order, which proved to be unlawful. His detention was uniquely linked to that deportation order. The unlawfulness of that detention is inescapable. The desiderata of finality and certainty cannot impinge on that inevitable result. Our case is simpler. We're only concerned here with the unlawful, and it is unlawful, rules which under which the appeal was heard and determined. And we say finality and certainty cannot displace those elementary propositions. It's no answer also for the respondents to say, as they do, that here the first tier tribunal had jurisdiction to determine the appeals. Indeed, in DN Rwanda, if the court still has it open, Lord Kerr addressed that at paragraph 19. As Lord Carnworth has pointed out, the principle can be displaced by a specific rule of law. There is no such specific rule of law in the present case. The existence of a right of appeal does not constitute such a rule. The Home Secretary argued the independent judicial decision was a step removing the legal error in question. I do not accept that argument. The notice of a decision to deport is a prerequisite to detention. Where the deportation order is invalid, the unlawfulness of detention is inevitable, etc., etc. The fact that the FTT did have jurisdiction to hear appeals doesn't help the respondents, because the decision of the first tier tribunal was a decision made under the fast track rules, which have been held to be ultra vires rules, and it doesn't assist the Secretary of State and the Lord Chancellor to say that the FTT was not responsible for the defect. Those were the rules that the FTT was applying. Applying Lord Kerr's approach, the appeal decision is inextricably linked with the defective rules which the FTT was applying. It is true, and the respondents point this out in their written case, the rules were in fact made by the Lord Chancellor. They weren't made by the Secretary of State, far less were they made by the FTT. In relation to whether they were made by the Lord Chancellor as opposed to the Secretary of State, it's at least since the decision of Lord Diplock in the Town Investments case, 1978 appeal cases 359 and 381, public law has recognised that ministers act not in some distinct capacity, they act on behalf of the Crown, or more realistically, they act on behalf of the government. In any event, the Lord Chancellor is a party to these proceedings. It's true, as the respondents point out, that the FTT has not been joined as a party, but at no stage has the Secretary of State or the Lord Chancellor suggested that the FTT should be a party to these proceedings. As I say, the Lord Chancellor is a party and he can defend the interests of the tribunals. And indeed, Mr. Justice Ouseley joined the Lord Chancellor as a party, despite the objections of the Lord Chancellor's counsel, who argued that he, the Lord Chancellor, should only be an interested party. If the court's interested in this, the court will see it at Mr. Justice Ouseley's judgment, paragraph 59, which is on page 240, my friend Miss Anderson appeared then, as she does today, for the Lord Chancellor, and at paragraph 59 on page 240, there is recorded in Mr. Justice Ousley's judgment my friend's contention that the Lord Chancellor should be an interested party rather than second defendant, on the grounds the proceedings were not really against the Lord Chancellor as maker of the FTR, but that depended on how the proceedings were viewed. I am satisfied, says the judge, in these lead cases whether the varies of the FTR has been raised directly or indirectly, the Lord Chancellor is an appropriate defendant, although it would not be normal for her to be joined as a defendant. Must have been Ms. Truss, who was then the Lord Chancellor, for her to be joined as a defendant rather than as an interested party if merely involved indirectly. Indeed, the FTT, and this was my answer earlier to my Lord Lloyd Jones, the FTT has not complained that it's not a party to these proceedings. Indeed, it itself adjourned the application to it to set aside the appeal decisions on the basis that that issue should be addressed by the administrative court. And I give the court the reference to that. It's Appendix Part 2B. It appears at 904, page 904, decision by the President, Mr. Clements, and at 907, paragraph 14, the FTT said that the applications to set aside are adjourned pending a ruling in the High Court on the lawfulness of the 2005 FTR, and that then led to the dispute as to who should decide the matter, which was resolved by the same judges of the Court of Appeal sitting as a divisional court. Lord Justice Singh also suggested, if I can go back to his Lordship's judgment, paragraph 89, which appears at page 209, his Lordship said at paragraph 89 on page 209 that he would add, as a matter of legal principle, if our submissions on this issue were correct, it would necessarily follow that even appeal decisions where the appeal was allowed would fall to be set aside, because they would be a nullity. That cannot possibly be correct. Well, I have a number of answers to that. The first answer to that, my lords, my lady, is that the suggested anomaly is no greater in the present context than in the context of the decisions relating to bias. The same objection could have been made in that context, but it didn't prevent the board reaching the decision it did in Miller and the later cases, particularly the one that my lady mentioned. The fact that in theory, someone who won their criminal case could say, well, it's a nullity, or somebody else could say it, is nothing to the point. And the reason it's nothing to the point, with great respect to, with genuine respect for Lord Justice Singh, it's unrealistic. There would need to be an application to set aside a decision in favour of the appellant. See Smith and East Ello, the case I referred to earlier. You don't bear the mark of invalidity upon your forehead. And the person who's won is not going to make an application to overturn a successful appeal. And the court may well think it highly unlikely in the real world that the Secretary of State, who's lost an asylum appeal, is going to challenge as invalid decisions of the FTT in favour of asylum applicants. And indeed, the respondents accept that. They expressly accept that at paragraph 3.28 of their written case at page 156. And I would suggest that even if, highly unlikely as it is, the Secretary of State were to make an application to overturn appeal decisions in favour of appellants, the court would there exercise a discretion to refuse to grant any remedy, because the Secretary of State would be relying on the government's own decision to impose what the courts have found to be unfair and ultra vires rules. The consequences of the decision are relied upon, the consequences of our argument are relied on in one further respect. The respondents, in their written case, it's paragraph 1.7 at page 141, rely on what they describe as, quote, the serious burden, unquote, which would be borne both by the Secretary of State and by the judiciary, they mean the first tier tribunal, if we were correct on this ground of appeal. And what they're saying is there would be a very large number of cases where appellants would be entitled to have their appeals heard again. Now, this, of course, falls into the category of argument identified by the President for the Court in Cox and Ministry of Justice 2016 Appeal Cases 660 paragraph 43, where the President, Lord Reid, in very colourful language said this is like the fat boy in the Pickwick Papers. Council are seeking to make our flesh creep. But more substantively, can I draw attention to the facts to which Lord Singh referred? It's at paragraph 25 of his judgment. It's at page 198. And at paragraph 25, Lord Justice Singh draws attention to the fact that in the case of Alvey, on the 4th of August 2015, Mr. Clements, who's the president of the FPT, used his powers to set aside all the appeal decisions made under the 2014 fast track rules. So a decision was taken by the president that all the decisions made under the 2014 rules, where there's an application, are to be set aside. And Mr. Justice Ousley noted at paragraph 9 of his judgment in this case, that appears at page 228, the bottom of page 228, last two lines, records that my friend Mr. Tam for the Secretary of State explained that the Secretary of State had not taken issue with that ruling of the President for essentially practical reasons related to the number of appeals affected and their comparative recentness, though the Secretary of State had concerns about it. And the numbers are set out in the same judgment of Mr. Justice Ousley at paragraph 69, which starts at page 241. I'll come back to page 241. Can I just pick it up at 242 at the top of the page, where Miss Leven, her submission is recorded. Miss Leven relied, so this is the top of 242. Miss Leven relied on the experience thus far of the effect of the nullification of the 2014 FTR and the first tier tribunal's approach to appeal decisions made under them. A total of 312 applications had been granted in respect of 873 appeals heard. I think, says Mr. Justice Ousley, that all 2014 first-tier rule applications dealt with by the first-tier tribunal have been granted, and that's our understanding, and there appears to be no time limit on them being made. So far, 59 applications have been made in relation to appeals under the 2005 first-tier fast-track rules. So the court sees the number of new cases under the 2014 rules, a substantial number, which the Secretary of State has not disputed, are entitled to have fresh appeals. In relation to the 2005 fast-track rules, so far there's only 59 applications in 2017. And if we go back to the beginning of that paragraph on page 241, we see that there is a much larger cohort of potential cases, because there were 10,000 appeal decisions under the 2005 fast-track rules, because of course we're dealing with 9 years of appeals, and that's why there's a much larger figures. Miss Leaven suggested, however, that this picture of 10,000 appeal decisions being set aside was unrealistic. The decisions would not automatically be set aside. An application would be required. The Secretary of State would not seek to set aside those that she had lost. Those who had been removed would not necessarily apply to the first-tier tribunal to have their appeal decisions set aside, and could be dealt with by an out-of-country appeal. And all of that is correct in my submission, that those who have lost, and let's assume it's a half, or perhaps slightly more, of those 10,000, many of them will have moved on from 2005 onwards, either geographically or temperamentally or psychologically. And they may have been removed from this country, they may have left voluntarily. Their stay here in many of these cases will have been regularized. So whatever the number of cases is nothing like 10,000. So the suggestion, if that is what is being suggested by my friend, that the tribunal is going to be swamped with cases, is in my submission not a realistic one. And in any event, the distinction between cases under the 2005 rules and cases under the 2014 rules is an arbitrary one. As I've shown the court, all those whose cases were decided under the 2014 rules are now entitled, if they lost and if they make an application, they're entitled to a fresh appeal. My client is not in that category, but she's only not in that category because her appeal was heard in August 2014. Had her case been heard in October 2014, her case would have been under the 2014 rules, and she'd now not be in the position of arguing this case as she now is. I should also mention, I gave a partial answer to my Lord Lloyd Jones. I should direct, please, my Lord's attention to the relevant paragraph of Lord Justice Singh's judgment, where his lordship refers to the question of who should consider these applications to set aside appeal decisions. He deals with it in paragraph 3 of his judgment at page 195, and that is to be read with the divisional court judgment which he gave at page 4475.
The passage, just if I may just make an observation about these important passages, that the action of the president of the FTT, Mr. Clement, does demonstrate that the FTT considers that it has power to reopen a decision that it has made. And that was a point I put to you earlier. And it may be...
I entirely accept that, my lady. The answer to it is, with the greatest of respect to the president of the FTT, he was wrong. But when he made that decision as to who is responsible, he's wrong for the reasons given by the divisional court in this case at page 4475. The divisional court consisting of the same judges as the Court of Appeal,
Indeed.
As Lord Justice Singh mentions at paragraph 3 at page 195. I'm relying upon the President's decision, not because I'm not, that he had power to make that order, but simply because that is what has happened, and the Secretary of State has accepted it. The Secretary of State accept that all those whose cases were decided adversely to them under the 2014 rules and who make an application should have their old appeals set aside, and they can have a new appeal. But your ladyship is right. The president did decide that, but he was with respect to him wrong to do so because of the divisional court judgment that post-dated that, and a judgment that has not been appealed in this case.
But if it's a question of jurisdiction, of course, the fact it's not appealed strictly doesn't affect the matter.
No, that's correct, my lady, but there's no appeal on that issue. There isn't an appeal to this court on that issue.
True,
I entirely accept if there were an appeal, the court could deal with it. If this court wants to say something about that, of course, I'm not standing in the way. I'm simply telling the court that it isn't an issue on this appeal, and I have no submissions to make on it. It makes no difference to my client whether the matter can be heard by the divisional court or it can be heard by the first tier tribunal.
Well, there is a difference. I'm so sorry, Lord Panic.
Not at all, please.
I was going to say there is a difference in which judicial body hears it, because of the powers of the tribunals are wider than the powers of the court quickly hearing a judicial review application. I appreciate the High Court's got unlimited jurisdiction and the tribunals are statutory bodies. But if you got to the FTT and it reopened a decision and it said, yes, you should have been able to put that report in and get one and put your case on that basis, it might be able to deal with it there in those proceedings rather than have to have yet another application.
Well, I understand that, and there's plainly considerable force in that. That's not what the divisional court held in the judgment to which I've referred. And
indeed.
I don't want to take time on that.
No,
please don't. Your ladyship is perfectly entitled, of course, to read that judgment. And if your ladyship doesn't find that convincing, your ladyship will say so. But that's the position. That's what they decided. It's not an issue in these proceedings. But I'm not, of course, it's not for me to inhibit your ladyship from addressing that if your ladyship thinks it appropriate. And I take your ladyship's point. There would be a broader range of steps that the FTT could take. I take that point.
Sorry.
No, please.
Now, I just want to say I don't want to use up what is very valuable time to you, but I did put my hand up a little bit earlier on another point, which is I hope you will help us if you think that there's some distinction to be drawn between the automaticity for which you argue in relation to judicial decisions as opposed to administrative ones. Because you've given us some cases just now about administrative decisions. Don't stop now, but if you want to come back to it.
Well, I only have, I think, 3 minutes, so let me deal with it now. I say no, I do not accept there should be any relevant distinction. If there is a distinction, the courts should be more concerned to maintain the approach for which I have contended in relation to judicial decision, and all the more so in a statutory context where Parliament has expressly required that there be a fair system of appeals. That's how I would put it, my lady.
Thank you.
Can I finally, my lady, just indicate to the court that on the facts of this case, that is TN's case, Mr. Justice Ouseley made a series of findings that begin at page 260, paragraphs 136 through to 138 and 143 through to 144, recording that TN was given leave to bring judicial review proceedings, and that Mr. Justice Ouseley, had he found in our favour on the point I'm now arguing, or indeed on the points to which Miss Harrison is coming this afternoon, he, Mr. Justice Ouseley, would not have refused relief to TN. He would have quashed the appeal decision, even on the ground that I'm arguing, if I be right in substance on that. He says that at paragraph 138 and 143. He also, and I should just mention this in the light particularly of the questions that my lady has asked me this morning, there was a further point in the TN case that in any event, Mr. Justice Ouseley accepted that TN should have a further appeal in relation to the medical report which she submitted after the appeal decision in this case. That was a report by Dr. Bingham, and that's dealt with at 144 and 146 on page 263. So she has a further right of appeal on that discrete issue. The issue that we're arguing about is, of course, still important to TN, because unless we succeed in this appeal, that further appeal will be conducted on the basis that all her other submissions, the earlier submissions, are bad submissions because they were rejected by the FTT in the appeal that we're arguing about today. And there's no dispute on that between my friends and myself. One other matter, so this is a case where the time limits points don't arise in relation to bringing a claim out of time. In relation to the other cases, and there are many cases stacked up, 59 or so, pending the judgment of this court in this case, I would submit that on the time limits points, if we're right, particularly on the main issue that I've been arguing, or if specific unfairness can be shown in any of those other cases, then it would not be right to refuse to hear those cases out of time, particularly given the very substantial nature of the defect that was identified by the Court of Appeal. It would be wrong in particular to rule them out on a temporal basis, because I say it is unrealistic to think that an individual claimant could have proceeded to challenge the fast-track rules prior to the judgment in the detention action proceedings that led to Lord Dyson's judgment. In reality, only an NGO such as detention action is likely to have the expertise and the information effectively to bring such a claim before the courts, an individual litigant such as TN and their solicitors lack the panoramic perspective, and they are too focused inevitably under the fast track system on presenting her or his appeal. They don't have time for this panoramic analysis that detention action brought. And those points are made very forcefully, in my submission, in the written case for the interveners, paragraphs 39 to 41. I recognise, however, there may be a distinction in cases where the individual has already been removed from this country. The Secretary of State may be able to say that the prejudice to good administration in such a case is very strong, although I point out that there is at least one case where a fast track appeal defect led a judge to order the Secretary of State to bring the appellant back for a full and proper appeal. That's the PN Uganda case at EF 4340, paragraph 63 to 65. I've trespassed into the court's lunchtime, for which I apologise, and Miss Harrison will have to bear the consequences of that. She's smiling at me, but subject to other questions on which I can try to assist the court. That's what I wanted to say on behalf of TN on the first issue.
Thank you, Lord Panic. I don't think there are any questions at the moment. Ms. Harrison won't have to bear the consequences because we'll sit again at 2 o'clock.
Well, I'm particularly grateful, my lord. Thank you.
Thank you very much.